Good afternoon, everyone, and thank you for joining us today. I'm Carrie Abrams, Dean of Duke Law School. I want to welcome you to what promises to be a truly engaging and timely discussion about the next 4 years. Over the past year and culminating on November 3rd, we witnessed what was certainly one of the most fraught and contentious political processes in American history, the 2020 presidential election. Normally, after an election, we as a law school would host an event to explore the legal issues faced by a new administration. But of course, this election, as we all know, was unusual because the results were contested by the sitting president. And so we decided last November to hold an event on evaluating the legal challenges to the election rather than jumping ahead right away to the new administration. Now, 3 months later, after an extraordinarily difficult but ultimately successful transition of power, we can finally take a step back, take a deep breath, and ask, what happens next? We have already begun to see glimmers of what President Biden's administration will offer, and we at Duke Law are very fortunate to have on hand some of the nation's leading experts on the legal subjects likely to be at issue in the new administration's agenda. This afternoon, you'll hear from Professor Stephen Sachs on the judiciary, Professor Guy Charles on voting rights, Professor Kate Evans on immigration law, our former faculty member and currently visiting Professor Jim Saltzman on environmental policy. Jim, we're delighted to have you back with us. And of course, our own Professor Kurt Bradley on foreign affairs. Thank you in advance to all of our panelists, as well as to Rachel Greason and Laura Grisham for helping to plan and run this event. Now, I'll turn the discussion over to Professor Marin Levy, who is director this year of the program in public law, which is sponsoring this event along with the Office of the Dean. Professor Levy, thank you for planning and shaping the substance of today's conversation. Let's begin.
Wonderful. Thank you so much to Dean Abrams, to the program in public law, and to all of you watching with us today. So as the Dean mentioned, during our event, we will be hearing from 5 of Duke Law School's own faculty members on what we might expect from the Biden administration in the coming years. After each panelist provides some initial remarks, we will be asking them questions. So please feel free to use the Zoom Q&A function down at the bottom of your screen to submit your questions at any time, and we will be sure to pass them on to the panelists and address them in the latter part of our panel event today. So to kick things off, we will be hearing from Professor Stephen Sachs. Professor Sachs is the Colin W. Brown Professor of Law here at Duke Law School, and he is an expert in civil procedure, constitutional law, and legal history. He will be speaking to us today on the topic of the judiciary. Professor Sachs, thank you.
Thank you. Thank you all for coming to hear us. The courts were a major focus of the 2016 campaign after the death of Justice Scalia, and some folks quipped that the GOP had 2 things on its agenda in the last term: to cut taxes and appoint judges, and that they checked both off of their list. The last 4 years saw 3 new Supreme Court justices, 54 appellate judges, and 174 district judges. That's a third of the Supreme Court, 30% of the appellate bench, and 27% of all district judges. So with such an extraordinary impact on the judiciary, it's natural that the new administration would naturally look to the courts as a focus as well. I'm going to speak briefly to its possible activities in 3 areas: first, at the Supreme Court; second, at the circuit and district courts; and third, in litigation practices and positions that the administration might take. So let's start with the Supreme Court. For the moment, there's little potential for new appointments unless Justice Breyer chooses to retire, which is the subject of much speculation, but very little actual knowledge. According to Above the Law, he's hired only 1 clerk for next term, but so have a bunch of other justices. The more complicated question is whether the administration is going to explore other kinds of changes to the Supreme Court or its structure, whether packing the court by adding additional seats, limiting the justices' good behavior terms, or even having a rotating cast of circuit judges stand in. These were a number of ideas floated during the Democratic primary, and right now the administration is putting together a commission to study the courts and to make recommendations. Its co-chair, Bob Bauer, has been skeptical of court packing, as has President Biden himself, but he has supported term limits for judges, which might face some serious constitutional problems. From the public reporting, the commission includes some folks who have been pretty vocal in favor of changing the judiciary, but also Harvard's Jack Goldsmith, who for a time headed the Office of Legal Counsel in the George W. Bush administration. So it's not clear yet whether the commission is the first step towards a revolution in the courts, or whether this is a way of defusing pressure from the left by creating a place where proposals go to die. And no matter what the commission says, anything it produces would still have to get through the House and Senate. Senator Manchin has already announced his opposition to court packing, and both he and Senator Sinema have expressed support for the filibuster. So it's very unlikely that we're going to see anything significant there. Secondly, on the circuit and district courts, here we do see a number of vacancies starting to open. A number of judges on various circuits have started taking senior status, and same with the district court. The administration thus far has made two moves of note. First, they've decided to follow the Trump administration in not having the American Bar Association vet candidates in advance. That role is a little bit odd for a private group of lawyers. The ABA has also been accused of various biases, either from the right or from the left. And not having ABA vetting allows the administration to move a little bit more quickly to make nominations and staff positions. Secondly, the White House counsel's office, led by Duke's own Dana Remus, has said that they're looking for a different kind of candidate than may have been traditional, not just on areas of diversity that are familiar to us, but many judges are former prosecutors or government lawyers. One report from the Cato Institute suggested that judges previously litigated for the government rather than against it by a margin of 7-1. And Remus has told senators that the administration would like to see former public defenders, former civil rights and legal aid attorneys, other non-traditional candidates suggested for district court nominations. That could have a real impact on the makeup of the courts. Third, I want to note areas where the Biden administration might have new litigation positions than the Trump administration did. Now, in most cases, the United States is going to take the same position no matter who's in the White House. Civil appellate and the DOJ will oppose your request for lawyers' fees under the Equal Access to Justice Act, no matter what. But in other cases, it does change course. So some of these cases involve President Trump personally. So for instance, in the defamation lawsuit filed by accuser Jean Carroll, the Department of Justice had sought to defend the suit on Trump's behalf, arguing that his statements protesting innocence were made within the scope of his job as president. The district court disagreed, and the DOJ is appealing. And there are some institutional interests there, but also potentially political ones. So we'll have to see what the new administration chooses to do. Another potential switch is in California versus Texas, the Supreme Court case on the validity of the Affordable Care Act. Here, it is likely that the new Department of Justice will disagree with the Trump administration's view that the entire ACA is inseverable and invalid. All the briefs are in and oral argument is over. So it's not clear whether the administration is just going to let the court make its own decision or whether it will want to weigh in with some sort of new supplemental filing. Also on the hot button issue list is affirmative action. During the Trump administration, the United States had filed suit against Yale, arguing that the university's policies violated the Civil Rights Act. It had also filed an amicus brief in a similar private lawsuit against Harvard. Last week, the DOJ dropped the Yale suit, and I imagine it may advance a new position when the Harvard plaintiffs seek Supreme Court review, which is something that could happen within the next few days, if I'm calculating the deadlines correctly. So in terms of structural reform, probably not too much will occur from the Biden administration. There will be some changes in judicial personnel, and we'll just have to wait and see what kinds of positions they take in the litigation, which is ongoing. So thank you.
Wonderful. Thank you so much, Professor Sachs. So we turn now to Professor Guy Charles, the Edward and Ellen Schwartzman Professor of Law here at Duke Law School. Professor Charles co-directs Duke Law School's Center on Law, Race, and Politics, and is an expert in constitutional law, election law, campaign finance, redistricting, politics, and race. Professor Charles will be speaking to us today about what changes we might expect in election law and voting rights. Professor Charles, I hand it over to you.
Thank you. So interestingly, voting rights is one area in which we might see significant changes under a new Biden administration. Now, part of it will depend upon Congress and what the Democrats are willing to do about the filibuster. But there are currently two bills in front of the House, actually the House had passed them a year or so ago, H.R. 1 for the People Act and HR 4. I'll spend most of my 6 minutes or so talking about HR 1, but I'll say a few words about HR 4 towards the end. So HR 1 is probably the most comprehensive voting rights writ large. So it's actually much more than a voting rights bill. It's an election law bill. And in some respects, it would completely redo so much of what we think about election law in the American space. So first focusing on the voting rights aspect of it, and I'll say a few words about the election law aspects of it. With respect to the voting rights aspect of it, this bill really does so much, or this proposal, I should say, because it will come. It may be modified, but it's the thing that the Democrats in particular, but voting rights activists really would like to see Congress take up, and would like to maybe even see the Senate pass the House version. Fundamentally, it does two things that one would expect a Voting Rights Act to do. First, it recognizes very explicitly that voting is a constitutional right. The right to vote is a fundamental right of citizens of the United States. And from that operating principle, it then goes on to do a number of things, starting with focusing on making the exercise of the right accessible. And it explicitly says that the right is hollow if it is not accessible. And both the failure to recognize that voting is a fundamental right as a matter of American positive law, statutory law, and the inability to make that right accessible has been major deficiencies of the American voting rights system. This bill has a number of interesting features, 5 or so of which are notable. First, it shifts the burden from individuals to the state. It centralizes election administration and voting practices. It standardizes voting practices. It limits state discretion, and it expands on the electorate. And I'll just give an example of each of those. So take the shifting the burden from of voting from individuals to the state or to the government. It states, HR 1 states explicitly, it is the responsibility of the state and federal government to ensure that every eligible citizen is registered to vote. And it does so, it shifts that responsibility to the state and the federal government by making voting registration automatic. The government must register the voter unless the voter opts out of registration. So that's a significant burden. Indeed, one of the things that one can do to make voting much more accessible is automatic voter registration. The other thing that it does along those lines is something that a number of states have done. It allows for same-day registration. Again, that's another way of shifting the burden from the individual to the states. And by shifting the burden from the individual to the states, you actually make voting easier, and you increase the pool of people who are able to participate. You make voting voting more accessible to a broad range of individuals. Second, as I mentioned, it centralizes certain aspects of election practice. One example of that is redistricting reform. So it mandates that congressional redistricting ought to be conducted by independent and state commissions. It makes it harder so that's one aspect. By now, we go from every state doing redistricting their own way to now there's a federal standard for how to conduct redistricting. It must be done by a commission. And then the bill also specifies the composition of the commission. It makes it harder for voters who are registered in more than one state. So if you move, there are times in which when people move from one state to another, they can be registered in 2 states, although obviously you can't vote in more than one state, but it's possible to be registered. So that makes that much harder. When a voter is applying for a driver's license, they can indicate where they resided previously and where they intended to vote. And then that information is shared centrally. So that way now there's information sharing that makes it harder then that people can be registered in more than one state. And so the voting rolls in each state are actually much more accurate and voting practices are better. It standardizes voting practices along a number of different dimensions. So it requires same-day registration, automatic voting registration, vote by mail. It standardizes how states count provisional ballots, right? So it takes a number of disparate types of things that states do that makes voting less accessible, and it standardizes those across states. It limits state discretion. So for example, it makes it harder for states to use interstate databases to purge voters from voter rolls. It requires that states have the full name of the voter, their date of birth, the last 4 digits of their social in order to then, before they can purge the voter from the rolls. And this bill would expand the electorate. So it makes voting easier for voters with disabilities. It makes voting easier for Native American voters. It restores voting rights to Americans with previous convictions, criminal convictions, and it makes voting accessible to young voters. And then lastly, it provides funding to the states, so that way the states can modernize their voting machines and registration practices, provides federal funding for voting audits and voting systems. So in many respects, from the voting side, it would really transform American voting practices. And then if you add in the stuff that it does on campaign finance, so it redefines and changes American campaign finance laws. It does a number of things on ethics and lobbying reform. It addresses cybersecurity and election security. So it really is an omnibus bill that attempts to restructure not just voting rights practices, but election law in the United States writ large. All right, so that's HR 1, which is entitled For the People Act. And now by contrast, we have HR 4, which is really just a bill that would, for all intents and purposes, undo the Supreme Court's 2013 case in Shelby County versus Holder, which struck down Section 4 of the Voting Rights Act. So for those of you who are not familiar with this, the Voting Rights Act has three central provisions. 2 of those 3 are sections 4 and 5 that identify those jurisdictions with a history of discrimination. That's section 4. And then section 5 requires those jurisdictions to pre-clear any changes that they have. If you change your voting rules, you have to first get permission from federal officials. The Supreme Court struck down Section 4 in 2013 in Shelby County, and HR 4 attempts to revive the Voting Rights Act because Congress finds that racial discrimination in voting is still a significant problem. Now, the major question is whether the Democrats will be able to get through one or both of those provisions. The current momentum is in favor of HR 1, although lots of civil rights groups are also pushing HR 4, so they're pushing both HR 1 and HR 4. And my guess is at least some parts, I'll be surprised if HR 1 gets passed in sort of like its omnibus provision. So my guess is that it will end up being curtailed in some way, at least to get through some bipartisan support through the political process. But HR 1 and HR 4 are the top priorities for the Democrats in the Biden administration, because they really do believe that if they can restructure election law and voting rights, both as a moral matter, but also as a political matter, it provides some significant advantages for that party. So let me stop here and turn things back over to Professor Levy.
Wonderful. Thank you so much, Professor Charles. So next, we will turn to the topic of immigration. We are fortunate to be joined by Professor Kate Evans, who is an expert in the field. Professor Evans directs Duke Law School's Immigrant Rights Clinic and teaches in U.S. immigration and nationality law. Professor Evans.
Thank you so much. I think it's All right, perfect. Just making sure my video is turned on here. So I come to this discussion not only as a scholar and teacher of immigration law, I have also spent most of my professional life advocating on behalf of immigrants and doing so alongside students who without fail put their heart, soul, intellect, and everything else into serving their clients. And it's from that perspective that I want to speak today. The last 4 years have been brutal as we've watched the courts close to the claims of asylum seekers and families with long-standing ties to the US, and seen immigration detention centers fill to devastating new heights. So when I think about the potential big changes I expect to see in the next 4 years, my list is long. Today, I'll focus on major changes the Biden administration is already making to immigration enforcement and humanitarian protection through executive orders and agency review. And then I'll highlight more fundamental changes that require, and I hope receive, congressional action. The overarching theme for these changes is the restoration of a sense of humanity and appreciation in our immigration policy. Because immigration has been such a prominent issue in the 2016 and 2020 elections, the Biden administration has already announced 20 separate policy directives within the first 2 weeks. So I'll summarize some of those and we might get to some additional ones during the question and answer period. First, enforcement. The Biden administration announced a fundamental recalibration of its approach on day one. This executive order started by stating that immigrants have helped strengthen America's families, communities, businesses, and workforce and economy, infusing the United States with creativity, energy, and ingenuity. The Department of Homeland Security followed this order and these sentiments with an announcement that it would prioritize enforcement against individuals who represent a national security threat, people with convictions designated as aggravated felonies, and recent border entrants. This targeted policy eliminates the prior dragnet approach that sent longtime residents, business owners, essential workers, crime witnesses, and DACA applicants into deportation proceedings. And in this way, it's a significant first step to prioritizing and realigning our resources with our national interests. What I hope we will see in addition is a substantially greater independence in the immigration courts. This is an institution that has been in desperate need of investment and reform for years, but saw particular erosion under the prior administration's case quotas and regulations that made defending our clients against deportation a Herculean task in the clinic. I also hope that the Biden administration takes seriously its stated commitment to racial justice, decarceration, and public health in the context of immigration detention. At the start of the pandemic, taxpayers spent more than $2 billion a year to jail about 56,000 people every day, the vast majority of whom are Black and brown. Immigration and Customs Enforcement became a major spreader of COVID-19 through transferring immigrants across the country and failing to protect the people it housed as well as the staff that worked there. 9 people have died in immigration detention and more than 9,000 people detained have contracted the disease. And this doesn't include the spread created in communities surrounding the detention centers during the pandemic. The detained population is now down to about 15,000 per night, an acknowledgement of how out of control the prior detention policy was. Unfortunately, our clinic is still fighting for the release of a client who spent 2 years in civil detention, has been exposed to COVID very directly at least twice, and has a pile of evidence to show that he doesn't represent a flight risk or a danger, which the Department of Homeland Security still has not reviewed. There are many proven alternatives to detention, and I hope the Biden administration will take these very seriously and stop the unnecessary destruction of people's lives and families. On humanitarian protection, there are new efforts to reunite children separated from their parents, to the horror of so many Americans, and stop the policy that led to that practice. Additionally, the US policy of preventing asylum seekers from entering the country to pursue their applications here resulted in the creation of refugee camps on the Mexican side of the border, a practice the Biden administration has also announced it will no longer follow. On top of this, we are seeing a full and complete top to bottom review of the layers and layers of restrictions to asylum and refugee protection. It will be no small feat to undo the damage to these laws. I hope that as a result of this review, though, the US will return to its place as a country that embraces our responsibilities under international refugee law. Finally, the reason we're seeing such dramatic swings of the pendulum in immigration law is the lack of congressional action on immigration reforms that could address the needs of businesses, families, and communities, so there's not such a wide open field left to executive discretion. Exactly how we balance family reunification, worker protection, the needs of US businesses, border enforcement, and humanitarian protection are subjects of important policy debates, ones I hope we will have soon. We've seen a proposal gain momentum on Capitol Hill already, and I hope we'll see the current bill move forward through this process so that Congress can finally achieve reforms to our immigration laws that have had broad bipartisan support for more than a decade. With that, I'll turn it back to you, Professor Levy.
Wonderful. Thank you so much, Professor Evans. Next up, we are fortunate to be joined by Professor Jim Salzman. Professor Salzman is the Donald Bren Distinguished Professor of Environmental Law with joint appointments at the UCLA School of Law and the Bren School of the Environment at UC Santa Barbara. He formerly was the Samuel F. Mordecai Professor of Law and Nicholas Institute Professor of Environmental Policy here at Duke. And as Dean Abrams mentioned, we are so lucky this year to have him joining us again, visiting Duke Law School this year. He will be speaking to us today about changes to environmental law and policy. Professor Salzman.
Thanks, Maren. It's nice to be back. So if you are an environmentalist, you are giddy right now. And to explain why and to look forward to the next 4 years, you need to start with the past 4 years. And to keep a sense of the dramatic, think of this as a 2-act play. So Act 1. Trump appoints ideologues to head EPA and Interior, and they are charged with dismantling climate policies, promoting extraction on public lands, and deregulation. Scott Pruitt, the former Oklahoma Attorney General, has such distrust of EPA staff, he spends over $60,000 to install a soundproof booth in his office. It's like something out of Get Smart. He and Zinke, the head of Interior, launch a blizzard of actions. They are high on enthusiasm, but they are low on understanding administrative law. They don't follow basic regulatory procedures. As a result, 90% of Trump's actions are challenged in court. They lose. This is a stunning statistic. It's almost always the reverse. The administration is losing 90% of their actions. That's Act 1. Act 2, Pruitt and Zinke are forced out. They are replaced by lobbyists, former agriculture and coal lobbyists. They understand agencies, they understand administrative law. Their changes are not so easy to reverse. So let's now look forward to the next 4 years, and I want to outline four big stories. The first is high profile. 1 week after taking office, Biden declares Climate Day. He signs an executive order on the climate crisis. This details immediate actions, priorities for regulatory reversals, procurement. It's very broad ranging. For instance, one of the things in the executive order is a so-called 30-30, conserving at least 30% of our lands and oceans by 2030. There's a public commitment to science-based decision-making, which, given the past administration, actually is a major reversal in policy. There is more focus on the environment within the first 10 days of the Biden administration than of any prior administration in the first 100 days. This is really different. Second major story is climate. All right, Biden has already made this a very high priority, and not just at EPA. What's important is it's a coordinated effort across government. So Gina McCarthy, who's the former head of the EPA, she's working out of the White House. She's going to be controlling domestic climate policy. John Kerry, former Secretary of State, he's going to be coordinating international climate policy. These are big time heavy hitters. They are ambitious, they have large staffs, and they took the jobs because they were promised a government-wide approach. And just to give you one specific example, a colleague of mine, Ann Carlson, she's a law professor at UCLA, she was appointed as the general counsel of NHTSA, National Highway Traffic Safety Administration. It seems an odd appointment. She's a Clean Air Act expert. NHTSA basically focuses on airbags and seatbelts. Why is she there? She's there for one reason, and that is to reverse the Trump policy on car and truck fuel efficiency standards. All right, so they've taken what was traditionally basically just a car safety job, and they've turned it into a climate job. Climate will be a priority across the government. The executive order said is the center of US foreign policy and national security. Third priority, or third big thing to look for in the next 4 years, environmental justice. Look at the appointments to the three most important environmental agencies: Department of Interior, EPA, Council on Environmental Quality. Deb Haaland is head of Interior. Michael Regan is head of EPA. Brenda Mallory is head of Council on Environmental Quality. Holland is a Native American woman. Reagan is a Black man. Mallory is a Black woman. Never before have any minorities headed these agencies, much less all at the same time. Biden is sending a very clear message that all of the environmental initiatives across the major environmental agencies will have environmental justice issues in clear focus. And Holland, Reagan, and Mallory have made this clear. In the executive order, they call for something called Justice 40. They promise to deliver 40% of overall benefits of federal investments to disadvantaged communities. Now, time will tell. Other administrations have talked about environmental justice, but this really is unprecedented. And the fourth big issue to think about over the next 4 years is reversing course, right? Trump administration basically put a bullseye on environmental and natural resources policies. This is easy to do with executive orders. It's just a stroke of a pen. It's not easy to do with regulations. There's going to be a lot of focus on State Farm. One of the big questions, and for public lands, there are a lot of questions about leases. One of the big questions, I think, within the government is going to be resource management, right? These agencies have limited resources and they have to make basically a rulemaking record to reverse a regulation. Then they have to promulgate a new regulation. They're going to have to choose their priorities very carefully. As Guy pointed out, there's slim majorities in Congress. And so this is going to pose the same problem as Obama in terms of getting major legislation. I'm going to stop here just to conserve time. And I'm happy to talk in the Q&A about specific initiatives in air, water, and public lands. The key point is environment is a focus really like never before.
Wonderful. Thank you so much, Professor Salzman. Finally, we'll be hearing from Professor Kurt Bradley, the William Van Alstyne Professor of Law and Professor of Public Policy Studies here at Duke. Professor Bradley is an expert in international law in the United States legal system, the constitutional law of foreign affairs, and federal jurisdiction, among other topics. He co-directs Duke Law School's Center for International and Comparative Law, and he will be speaking to us today on the topic of foreign affairs. Professor Bradley.
Thank you, Professor Levy. So in the foreign affairs area, I think we're going to see, in fact, are already seeing pretty significant differences, I would say, in both the process and the substance of Biden's approach to foreign affairs as compared to the last administration. I do think there'll be a few areas of overlap, and I'll just mention those near the end of my remarks, but the differences will be more prominent. So in terms of process, one thing to note is I would think that Biden's approach will be less personality driven in his approach to foreign affairs, not turning on whether he thinks particular foreign leaders are friendly to him personally or complementary to him, whereas we did see some of that under Trump. I also think we'll see a less impulsive kind of erratic foreign policy. I think we'll see that major decisions are vetted heavily within the executive branch among the different departments and agencies, and we won't be as surprised by sudden shifts in policy directions as we were in the last administration. In terms of substance, the biggest thing that we're already seeing is going to be one of re-engagement, and that's going to be with international institutions, treaty regimes, and allies. After the Trump administration's very different so-called America First approach. And Biden just gave his big first foreign policy speech the other day, and he emphasized, quote, America is back. And he meant by that, it's back in re-engaging with the world. And we've already seen some concrete steps in that direction. One is, and of course overlaps with the remarks we just heard about the environment, is the Biden administration has moved to rejoin the United States to the Paris Agreement on climate change, which the Trump administration had withdrawn from. They've stopped withdrawal from the World Health Organization, which Trump had initiated. And my guess is we'll see an effort to get the US back into some nuclear deal with Iran, maybe with some modifications after Trump had withdrawn the United States from that arrangement as well. We're seeing already steps to try to rebuild alliances, including with NATO. And so just the other day, for example, Biden announced a pause on withdrawing troops from Germany, just to further reaffirm the US commitment to NATO and the NATO allies. I also think we're going to see a much greater emphasis in the next 4 years on human rights and democracy promotion. as part of American foreign policy than we saw the last 4 years. We're starting to see it already with the withdrawal of US military support for the Saudi conflict in Yemen, given the atrocities there, and also just the strong condemnation the other day of the coup in Burma or Myanmar. And the administration, in fact, announced also today that it was going to move to rejoin the United States to the UN Human Rights Council, which the Trump administration had withdrawn from. In terms of specific relationships with other countries, of course, a big part of foreign policy, I think we're likely to see a more adversarial relationship with Russia than we saw under Trump. And in fact, Biden, when he had his recent call with Putin, made a point of emphasizing concerns about interference in elections, cyber attacks, poisoning of political opponents, things that seem to be underemphasized in the last administration. But I think Biden will also try to work with Russia, particularly on things like arms control. And in fact, one of his first acts was to agree with Russia to extend the New START treaty by 5 years, which limits nuclear armaments. And I think we'll see more of that. Those are some of the prominent differences. I think on a few issues, we'll see some overlap with Trump. So for example, Biden, like Trump, does not like forever wars, significant troop engagements overseas. And so I think he's similar to former President Trump in that regard. And I think like Trump and also Obama, he will look for using targeted uses of force and drone strikes and the like to deal with the ongoing problem of international terrorism. I think like Trump, he's also going to have a pretty adversarial relationship with China, particularly on trade issues. And like President Trump, I think Biden has some protectionist policies, in mind. He's already issued an executive order, a Buy America order, and I think we'll see continuing trade issues with China. Having said that, I think the Biden administration will be more interested in working with the World Trade Organization and being supportive of that institution in its dispute settlement provisions for trade disputes, unlike the Trump administration. Another big relationship is, of course, always with Israel. I think we're likely to see something much closer to what we've seen in presidencies before Trump. That is basically treating Israel as a close ally, but continuing to encourage it to work towards a two-state solution with the Palestinians. But I wouldn't expect significant reversals of Trump policies, concessions to Israel, like having moved the embassy to Jerusalem. I think it's important to note that in any of these programs, Biden will face significant constraints in the foreign affairs area. There has been a loss, I think, in confidence in the United States in the international community as a reliable partner. That would have to be rebuilt. And it's also just a very challenging international environment. We have geopolitical competition from China, various threats from Russia, and regional dangers from countries like Iran and North Korea, which will not go away. And there'll be lots of challenges domestically. Some of them are just all the priorities you've already heard about from the other speakers. A lot of difficult issues at home, including, of course, the pandemic, and a lot of partisanship in Washington that will also not go away. And it will make it difficult to do things like conclude any new major treaties. And Biden will have to find ways to work around some of those limitations. I do think he'll find some areas of possible bipartisanship in foreign affairs. Just for example, the Republicans were not in agreement, I think, with Trump with his antagonism towards NATO, for example, and are likely to be supportive of Biden in that regard. And similarly, I think they may support Biden with respect to issues with Russia and Saudi Arabia. They didn't always agree with Trump on those issues. And I think they may support initiatives like Biden's efforts to increase US cybersecurity, to take an example. So in short, I think we're going to see an approach to foreign policy in the next few years that is much more deliberative, I would say multilateral, and probably values-based as compared with Trump's approach. But I think there are going to be a few areas of overlap as well. Thank you, and I look forward to any questions you might have.
Wonderful. And thank you all so much for those very insightful comments to kick us off. So a number of questions have started to come through via the chat function, and I encourage more to submit questions now. We're just going to open with a few of our own. So the first, I was hoping to ask everyone here that this touches on a few substantive areas a little bit more than others. It's come up quite a bit in news reports, and that is the use of executive actions. So in fact, an article from this weekend on CNN ran with the headline, "On executive actions, Biden is blowing his predecessors out of the water." So we've spoken about what changes might come about from the administration, but I think it would help if we talked for a moment on how those changes will come about. So are you all surprised to see quite so many executive actions? And in particular, what does this mean for the stickiness or the staying power of these policy changes? And in particular, I'm thinking here about in the environmental space as well as immigration. So Professor Salzman, Professor Evans, do you want to jump in?
You know, Mary, when I get unmute out of my vocabulary, I'm going to be a happy camper. Sorry about that. So this ties in with climate change, right? So during the Obama administration, he was not able to get climate legislation through. And so he relied on executive actions. And as you noted, new president comes in and it's flipped. And so we're really in an era of, I think, whipsaw policy, which is each administration comes in and undoes the executive actions from before. But you aren't given a lot of choices. And I think for climate in particular, Biden's going to try hard to try to get some kind of climate legislation through. It's not going to be the Green New Deal that folks are talking about. But right now, they're basically with the Clean Air Act. Clean Air Act was not designed to deal with global air pollutants. It's like serving soup with a fork. And so unless you get some kind of climate legislation, you're going to keep relying on these executive orders. And if a Republican wins the next election, it'll flip back. And so I think it's unfortunately more of the same.
Yeah, and I just had in there, I think the immigration space, as I said in my initial remarks, because Congress has not similarly engaged in the space to sort of resolve the very large area in which prosecutorial discretion operates, it is a big space. It was a big space under President Obama and then Trump and now Biden. And I think, you know, in that way, it's sort of a choice by Congress as to whether or not to step in. Absent sort of a reorganization of the immigration laws that would resolve the questions concerning about 11 million people who are here without authorization, the fates of those individuals and their families will be left to the power of the president's pen, based on, you know, that executive power to decide who to enforce the laws against. It's an application of prosecutorial discretion, just like it is in a criminal context. And so I think it's unsurprising to see the number of executive actions we've seen in this space from on the immigration front. And you know, like Professor Salzman mentioned, so many of these start with value statements and start with sort of what the assertion is of the administration concerning, you know, those policies that can be reviewed. But most of these are promises to review, you know, precedential decisions, rules, regulations, the extent to which they really can roll those back, I think, you know, remains open. They will have to go through, you know, a rigorous rulemaking process. And I think, you know, when, assuming Judge Garland does get confirmed, you know, the extent to which he's willing to reach out and take back, you know, very formal interpretations made by his predecessors, you know, I don't know, that remains to be seen. And that will determine a lot of what actually happens here and, you know, beyond proclamations to study the issue.
Great, thank you both so much. The next question we have is a two-parter. It's for Professor Sachs on the judiciary. So the first part concerns the topic of term limits. Professor Sachs mentioned this in his opening remarks. So as we know, this is the one reform proposal at the Supreme Court that has the most public support. And in fact, came to us quite a bit ago. Our own Paul Carrington, former dean of Duke Law School, is one of the folks who originally put this on the table some years ago. So you mentioned that there are some constitutional issues potentially with that. I was wondering if you could speak to those a little bit more. And the second question concerns the courts of appeals. It's been noted that those courts have not been expanded at all since 1990. And I was wondering what potential you thought there was for adding some new judgeships at that level, if the Biden commission might take that up or it otherwise might come about.
Sure thing. So the Constitution says that the judges of the United States are going to hold their offices during good behavior, and that has generally been interpreted as meaning without a particular term of years. So the ability of Congress to impose term limits, especially on a retrospective basis, saying that folks who have already been there for 18 years or so will have to step down, seems very limited. It's hard constitutionally to distinguish that from a rule that says, well, now there's a 1-year time limit, so everybody appointed last year has to go, and now we have 9 new seats, and we're going to repeal the time limit after that. So it seems a little bit difficult to do that. There are various proposals to try to restructure the office of Associate Justice of the Supreme Court, for instance, on a going forward basis, so that any new appointees would have 18-year terms, at which point they would then have some other kind of judicial office. It's not totally clear that that works. We have various institutions at the circuit court level and the district court level. We have senior judgeships, and there is a position for retired justices of the Supreme Court. But your ability to create an office whose duties change that much without reappointment could only be done on a prospective basis. And it's not clear that there's really a lot of appetite for that, because the benefits of such a change wouldn't be seen for at least 18 years in the future. So it's a little bit hard to see the political will for that coming together, even if it could vault all over the constitutional difficulties. In terms of the circuit courts, the size of the courts is up to Congress to decide how many officer positions they want to create by law. But it's also pretty contested, because anytime you create some new judgeships, you're letting the current administration staff those judgeships. So the circuit courts were expanded significantly under President Carter, and the effects of that sort of lasted a very long time. One reason why President Trump was able to appoint so many appellate judges is because a number of vacancies had opened up. Sort of now was the point in the cycle when people were leaving the courts. So, Congress certainly could do that. It might do that. There's arguments for having larger circuit courts than we currently do. But of course, it's unlikely that the minority party or the opposition party will ever want the current president to be able to appoint a large number of judges. Stephen Calabrese at Northwestern had proposed doing this in 2017, but a lot of Republicans had publicly opposed the idea of anything that might look like packing the circuit courts. And likewise, I imagine they're going to be no more eager to do so under President Biden. So unless the filibuster were broken, I don't think you're going to see new appellate judgeships coming up anytime soon, unless they're sort of phased in over a very long period of time.
Wonderful. Thank you, Professor Sachs. So our next question comes to Professor Charles. So the question is, what impact, if any, do you foresee this new administration having on states' voting rights issues in the courts, like Florida's highly contested, that is by the state, restoration of ex-felon voting rights? And I would just add on to that, as long as we're talking about the states, what you think of some new initiatives in states to shift or change voting rights. For example, an initiative we're seeing in some states right now to restrict absentee voting going forward, and how the administration will be able to respond to that.
Well, part of it depends on what happens with HR 1 and HR 4. So to the extent, if both of those are passed and if they're upheld after being passed, so it's one, dubious that they'll pass given the filibuster. So that's at least not in their current form. And then they will be challenged, in particular HR 4 will be challenged. And my guess is that under this current court, HR 4 will be struck down. So I think given those considerations in terms of the statutes, then the best thing that can be done is litigation. Now, what we're seeing with voting rights after the election, obviously, is that voting rights have become the new battleground. And so absentee ballots, but even same-day registration, vote by mail, the number of devices that make it easier for people to vote have also become the place where we're now fighting the turnout game and the power wars. And so now HR 1 wants to take those things outside of the voting process in some ways by passing a law and a statute that makes it illegal not to have same-day registration, for example, or makes it illegal to disenfranchise somebody because of their prior criminal conviction. But outside of these statutes, then we're simply left to the same devices that we have now, which is litigation. And for the most part, what we're thinking about in litigation are some of the fundamental constitutional rules. So if a state statute is passed to make it easier for people to vote because of their race, and you can prove that, then you can strike it down. But otherwise, it becomes really, really hard. The court often applies a balancing test and defers to the state, as we saw even in the context of a pandemic. The federal courts generally deferred to the states unless they had really good reason to believe that there was something that infringed upon voting as a fundamental right. So I don't think the Biden administration, outside of urging for the passing of HR 1 and HR 4, can do that much more. The Justice Department might be a bit more aggressive than under Trump. Well, it will certainly be more aggressive than under Trump. But they also risk the ire of the court. So I think that will impose some set of limitations on what they can do.
Wonderful, thank you. So the next question goes to Professor Bradley, and it concerns the United States' relationship to the International Criminal Court, in particular, whether we think it will continue to be adversarial as it was under the Trump administration, now looking ahead to the Biden administration.
Yeah, that's a great question. And it'll be interesting to watch, I think, the U.S. relationship to the International Criminal Court. You know, well over 120 countries are parties to the court. The U.S. is not a party to that tribunal. And the Trump administration became very adversarial with the court, even imposing sanctions against officials from the court after they allowed an investigation of possible war crimes in Afghanistan. Certainly, I expect a less adversarial relationship between the Biden administration and the court. I would expect that probably those sanctions will be removed. I don't think we're going to join the court in the next 4 years. That would take a new treaty, and I don't see 2/3 of the Senate likely to agree to the U.S. joining the court. There are too many sovereignty concerns that would be raised, and I do think that the Biden administration will try to work with the court selectively on cases that seem to be in U.S. interest, but there will be conflicts. We just saw it the other day when the court allowed an investigation of Israel with respect to possible war crimes in the Palestinian territories, and the Biden administration immediately came in very critical of allowing jurisdiction over that matter. So I think there'll be some points of conflict, but overall, I think a less adversarial relationship.
Terrific, thank you. So we have a few other questions that are a little bit bigger picture for any of the panelists to consider. So the next question is, many of the panelists mentioned racial justice as an issue that the new administration is prioritizing through affirmative action, voting rights, eliminating racial discrimination in immigration law, environmental justice, and the like. Are there legal impediments to implementing this priority, such as constitutional limitations on how much race can be expressly considered in legislation? Does anyone want to jump in on that question?
Well, I can take an early stab at it. As I mentioned in the voting rights HR 4 context, I expect this current court to strike, if that passes, I expect this current court to strike it down. So I think that imposes some limitations on how much the motivation for the statute, which would be the 14th and 15th amendments. With respect to other things that, say, the Justice Department can do with respect to voting, I think they can be a little bit more aggressive there to make sure that states aren't engaged in discrimination and voting. And so I think that's different than what we're talking about in terms of HR 1. So I think part of it just depends obviously on what the administration wants to do, and that will impose some different types of constitutional limitations.
Yeah.
I should, oh, sorry. I should add, this is not my area of expertise, but there may be various statutory restrictions, for instance, Title VI of the Civil Rights Act, and various constitutional restrictions under Adirond, the doctrine of reverse incorporation, that the federal government is bound under the Fifth Amendment by the same equal protection standards that the states are bound by under the 14th. If there were a policy that the administration were pursuing that a state would not be allowed to pursue, we could imagine it being challenged under those grounds. So it would really come down to what the courts understand the 14th and Fifth Amendments to forbid.
Yeah, and I think within the space of immigration law, as my students right now in immigration law and policy are looking at with, I think, some frustration, there is a huge amount of power to regulate, including on bases that would not otherwise be permissible on domestic laws. And so I think there's a lot of space to be very proactive, like with the end of the Muslim and African nation ban, talking about values and what sort of what kinds of messages the administration wants to send, you know, as a matter of foreign policy, as a matter of sovereignty, as a matter of sort of national character. And so I think those spaces, you know, are quite significant within immigration law. Detention policy, on the other hand, I think is more constrained. And so that becomes an area in which, you know, really looking at the prosecutorial discretion choices of who goes in and the very tight connections that immigration detention has with policing policies is one that will continue to be a demand for this administration, because you see race-based policing leading to race-based detention for years in some instances for immigration. So I think those two operate on sort of separate tracks that are you know, harder to get underneath of when you're talking about detention alongside deportation proceedings.
Wonderful, thank you. And I know we have just a few minutes left, so we've got one last big question for everyone on the panel, and that is, what is next for our profession? Do you think that current soul searching about the role of attorneys in promoting false narratives, entrenching racism, and facilitating political violence will lead to any substantive changes? Do you expect accountability in any specific areas or programs based upon your current understanding of the last 4 years? If anyone wants to take a stab at that.
So I would say that focusing on the issues sort of post-election and leading up to January 6th, I would say that the attorneys actually acquitted themselves reasonably well. If you look at the various parts of the government and how they responded to the claims about the election, the courts were the least responsive compared to you know, other branches. The DOJ rejected attempts by the White House to encourage them to intervene more forcefully, and it was really representation in Congress. So it was democracy that was the real you know, problem there. You know, so I don't think that the legal profession in the sort of post-election crises, you know, is really experienced a black mark. I think that the question would be, are there things that occurred prior to that where we felt that lawyers were acting quite wrongly? I'm not sure that the Trump administration posed the same sort of very precise legal ethics kind of questions that, for instance, the Bush administration and the torture memos did, and others on this panel might have more expertise there and be able to comment more. I think that there were a number of areas where there were where there were deep objections to policy and the justice of a policy, and also areas where sort of maybe the bounds of non-frivolous argument were being pushed. I'm thinking in part on the Justice Department's very careful brief in the ACA case about exactly how far they would go to endorse the White House's position and what they would not say. But I'd be curious as to whether other folks on the panel think there are places where lawyers clearly overstepped the line.
Does anyone else want to have the last word? No? Well, perhaps we'll leave it at that. We are just on time, so this was perfect. A huge thanks again to Dean Abrams and the Program in Public Law for sponsoring this event, and to Rachel Greason and Laura Grisham for helping to make it possible, to all of you for watching, and then especially to our panelists today for providing such rich and insightful commentary. Thank you all so much.